Thanks for joining us on Capitol View. I'm Fred Martino. The Joe Coleman Medical Release Act was expected to free hundreds of terminally ill and medically compromised prisoners in Illinois. But an investigation from Injustice Watch and WBEZ revealed only a few dozen were released. Illinois Governor JB Pritzker held a news conference where he said the law is being carried out as it, quote, should be. My guest disputes that. Jennifer Soble was lead author of the Coleman Act. She is also executive director of the Illinois Prison Project. That is a nonprofit legal group representing medical release applicants. Jennifer, thank you so much for being with us.
Thanks so much for having me.
Good to have you here. So I want to start with the numbers. How many terminally ill and medically compromised prisoners in Illinois have been released, and why are the numbers lower than expected?
Yeah, less than 60 terminally ill or medically incapacitated incarcerated people have been released to date. The law went into effect January 1st of 2022, so it's been rolling for about 18 months now. I think there are a couple of reasons as to why the numbers have been so low. It's a brand new law, so it did take some time for the law to go into effect, for the Prisoner Review Board and the Department of Corrections to create policies and procedures to carry it out, and for people to actually get to a hearing date and get released. The bigger problem, however, has been the rate of denials coming out of the Prisoner Review Board. To date, around 150 people have been found eligible for release. That means a doctor from the Department of Corrections has certified that they are either terminally ill, meaning they will be dead within 18 months, or they're medically incapacitated, meaning they're disabled. They need help with at least 2 activities of daily living. It's not a huge number of people who have been found to be certified as eligible, but of those people, every single one of whom is either within the last months of their life or so disabled that they need help doing things like toileting, moving around, getting their clothes on, feeding themselves. 2/3 of those folks have been denied release by the Prisoner Review Board.
Okay, very important. And here's another important point from the story. The Injustice Watch and WBEZ report says that an independent monitor appointed by a federal judge found Illinois prisons are unfit to provide health care for the thousands of aging, disabled, and incapacitated prisoners. Tell us what you found looking at this situation.
Yeah. The Joe Coleman Act was designed really to do 2 things. It was designed first to make sure that dying or disabled incarcerated people can be released so that they can get adequate medical care. But the other thing that the Coleman Act was designed to do was to relieve the burden of expensive and time-consuming health care from the prison system itself, because that system is so over capacity. The Illinois prison system's healthcare system has a 50% vacancy rate right now. That means that 1 out of every 2 nursing, physician assistant jobs are empty, which means that that healthcare system is simply not in a position to provide basic everyday care, checkups, acute emergencies, appendicitis, things that just come up in the normal course of everyday life. When you layer on top of that the care for people who are terminally or chronically ill, and here I'm thinking about things like stroke patients, cancer patients, folks with Lou Gehrig's disease, folks who will never get better and whose care is unbelievably difficult to manage, you have a pressure cooker, you have an unsustainable system. The Joe Coleman Act was designed to alleviate some of that burden by creating a mechanism to shift some of the most time-consuming and costliest incarcerated people, who also happen to pose no risk whatsoever to the community, and shift their care back to their families and their loved ones.
Care of individuals, very important to keep in mind. I understand, though, as you pointed out, there's also a financial issue here. If more eligible prisoners were released, it would reduce costs for the state. Give us a sense of the financial cost.
The financial costs are hard to calculate because they're so big. And I'll just give you an example to help folks understand why this is important. I had a client who was struggling with cancer, um, and we were able to get him released through the Medical Release Act. Before we got him released, we got his hospital bills for the last year of his life. And every cent of these bills was something that the Department of Corrections and thus the state of Illinois were paying out of pocket. Incarcerated people are not eligible for Medicaid or any federal assistance. Caring for my client in the last year of his life cost the taxpayers in this state $100,000. It's just a tremendous amount of money for one person for 1 year, and that's on top of everything else.
Right. And of course, folks are initially thinking about medical cost. What isn't even put into this calculation, as you're aware, all over the country, when there have been cases where states have been found not doing their job to care for prisoners, there have been lawsuits too. So that could be a potential cost.
Oh, absolutely. What the federal monitor that you talked about just a second ago found was that folks were getting their routine specialist care deferred until people were so sick that they were incurable, that they were terminal. There have been many cases of folks who had very treatable forms of cancer, but because the prison system was so overburdened, they weren't able to get the test that they needed to get diagnosed. And by the time they got diagnosed, it was too late. That not only leads to a tremendous loss of life, which is a moral hazard to be sure, but tremendously costly litigation.
Yeah. Well, the report notes that failing to release these prisoners also undermines care for the incarcerated who are not eligible for release under the Coleman Act, because medical staffing, as you pointed out, is a major issue. This is something as well that may be overlooked as we talk about this issue, but it can't be, right?
No, it absolutely cannot be. The Illinois prison system has infirmaries, permanent infirmaries, sort of like little hospitals within each facility. Every single one of those infirmaries is full to the brim. In every single prison in the state of Illinois, there are people who are so sick that they should be living in those hospital settings, but they aren't, just because there isn't a bed available for them. The Illinois prison system right now is 25% elderly, and that number is climbing every single day. These are folks who, because of their age and because of years and years of poor health care, as we just discussed, have tremendous medical needs. And this isn't going away. This problem is only going to get worse, not better. If we can't find a way to release the sickest, the most permanently disabled from our prison system, we are only going to continue to generate more and more folks who are sick and unable to care for themselves because they aren't getting the preventative or even maintenance.
Okay. Well, if folks are just joining us, the reporting indicates that part of the challenge is the Prisoner Review Board. You've talked about that briefly, but I want to delve into the problem there.
Sure. So the way the process works is a person applies for medical release because they believe that they are either terminally ill or medically incapacitated. And before their case can even get to the Prisoner Review Board, the Department of Corrections has to certify that, yes, in fact, the applicant is sick, is terminally ill, or is disabled. Once you get to that stage, the Prisoner Review Board has to give an up or down vote, basically, to say you can be released or you're not. And what the reporting revealed was that in 2/3 of the cases, the Prisoner Review Board is voting to deny release to a person who's already been found by the Department of Corrections to be terminally ill or medically incapacitated. That's a really shocking number. It's a really shocking denial rate.
Okay. The report notes that advocates want lawmakers to institute several changes to the Coleman Act to encourage the Prisoner Review Board to release more people. Let's talk about some of those ideas. First, they say that lawmakers should require board members to visit prison infirmaries to see firsthand the state of prison health care. Your thoughts on this?
Yeah, I think it's a really great idea. I will tell you that we get phone calls from nurses and doctors who are working in the prisons saying, can you please file a medical release application for this incarcerated person or for that incarcerated person? Their care is so burdensome to us. They should not be here. The prisoner review board does not understand, and how could they if they're not there, right? They don't understand how dire the healthcare system in the prisons are. They don't understand how burdensome it is to care for a person with the kinds of terminal or chronic and disabling conditions that come before them every day. So I think in order to understand the power of this law and how necessary it is to implement it to its fullest, not only the prisoner review board, but more folks in the legislature should be visiting prison healthcare units so that we all have a better sense of just how urgent the need for full implementation of this law is.
Here's another idea. The board should receive more training on how to evaluate the medical conditions of prisoners applying for release. Your thoughts on that?
Yeah, I also think that's a wonderful idea. The law is new. This law was passed in 2021 and it went into effect just 19 months ago at this point. And I think everyone within the system could benefit from more training, both to understand the intent of the law and the impact the law could have if it were implemented more fully, but also to understand what having a series of conditions could mean, both for an incarcerated person and for the healthcare staff within the prison where they're housed.
Yeah, so important, and that context, well, I'm sure would agree, is just essential when you're making these kinds of decisions. Advocates also want the state to provide prisoners who are applying for medical release with an attorney. Your nonprofit has represented some of these prisoners. Tell us about the need in this area.
Yeah, I think this is a really important recommendation. What we've seen is that when folks apply for medical release with an attorney, the grant rate is significantly higher than when folks apply for medical release without an attorney. And that makes a lot of sense. Attorneys are able to explain to the PRB about the incarcerated person's condition, about the way that their healthcare is impacting the Department of Corrections, about where they would go if they were released, about them as a person. And if without such an advocate, incarcerated people don't have anyone to go to the prisoner review board and share their story and share the impact of their illness, both on themselves and on their loved ones, but on the larger prison population. The huge disparity in grants for folks who are represented versus folks who aren't should be a red flag that there's something else going on here, right? It's not just about the applicants who don't have lawyers. There's something about them. It's about the process, that there's a tweak that we can make to the process to make this system work better, more fairly, and to be more advantageous for us all.
And I'm sure there are people watching this right now who are surprised that this is not already required to have an attorney provide.
Yeah, there are very few spaces after a person is convicted where they are entitled to legal representation. And it's part of the mission of our organization to increase access to counsel for incarcerated people, because there are so many who are serving sentences or whose current incarceration is unlawful or unjust. And if they only had someone to tell their stories, they would be released.
Yeah. Here's another one that seems, some may say seems very basic. Advocates say that lawmakers should require the board to explain why they denied a medical release. Your thoughts on that?
Yeah. What we're seeing right now is a huge difference between the way cases are treated that seems to have very little to do with the incarcerated person or their condition. So, for example, there was a case that was talked about in the report, in Justice Watch's report, two people, both of whom had dementia, both of whom had very loving families willing to take them into their care, both of whom were serving similar sentences for similar crimes. And one was granted and one was denied. And there wasn't any great objective reason why one case would be granted and one case would be denied. And so having the Prisoner Review Board be explicit about why they're granting cases or why they're denying cases might bring more uniformity, predictability, and transparency to the process.
Okay. I want to get into some background now, Jennifer. If folks are joining us midway through this conversation, you were the lead author on the Joe Coleman Medical Release Act. Tell us how you got involved in helping to write this very important state law.
Absolutely. I was representing a wonderful client named Joe Coleman. Joe was a Vietnam veteran. He had 6 wonderful children. He was just a really fabulous guy. He was also serving a natural life sentence for robbing a gas station. It was an armed robbery. His weapon of choice was a bright orange gas can. He didn't have an actual weapon. And he was serving a life sentence for that case. He was told he was irredeemable and he was not going to be permitted to go home. About 40 weeks into my representation of Mr. Coleman, we found out that he had prostate cancer and that he had developed dementia. And he declined very quickly. Knowing that he had this huge family, all of whom wanted to bring him home and into their care, I called the state's attorney's office and talked to the state's attorney and said, hey, will you agree to let Mr. Coleman be resentenced so he can go home? And the state's attorney said, I have no problem with him being resentenced, but the way to do this is through clemency. Clemency before COVID in particular was a really difficult process. It was very slow. It was very cumbersome. And so we tried to file a clemency petition and it was rejected because Mr. Coleman had not himself signed and notarized the application. I will tell you that by this point, Mr. Coleman was unconscious most of the day. His son and I worked really hard to get power of attorney transferred, to get a new petition put together. And while his son was driving the petition to Springfield because we didn't want to waste a day with the mail, and I was driving to the prison to see Joe, we found out that he had passed away. And it was a heartbreaking moment, but it spurred us into the creation of a system, of a process that would be faster, that would be easier than clemency, that would be more transparent and will require less, or so we'd hoped, legal expertise to navigate. The idea was to create a system where medically incapacitated and terminally ill incarcerated people had a straightforward mechanism that they could access to get some relief and return to their families and get the care that they deserved.
Okay, very interesting, and I'm sure many people who are watching this show, it's the first time they're hearing about the Medical Release Act and the history of it, so I think it's important to share. I want to give you a chance, too, to share a larger bit of information on how you became involved in prisoner rights.
Yeah. Well, I've been a public defender my whole career. I was a public defender in Washington, D.C. for a long time, and then in the federal system here in the Midwest. And it always struck me that although the Sixth Amendment gives people who are facing felony charges for the first time a right to an attorney, that right expires. It goes away after a person has been convicted and sentenced and through basically one round of direct appeal. And what that means is that there are literally in Illinois thousands of incarcerated people who are serving sentences that are unjust, that don't make any sense 10, 15, 20 years after they were imposed, sometimes that are wrong. People whose outdates can be wrong by years, if not decades, because of errors made by the Department of Corrections, because of errors made by judges that don't rise to the level of constitutional violations and so cannot be remedied through traditional post-conviction processes. And it struck me that if we are going to keep people in prison under a set of legal rules, because prisons are operated by a set of legal rules, it's not reasonable to ask folks to navigate that system completely without assistance. And so the idea of extending access to counsel, the right to counsel to incarcerated people, is the mission and goal of this organization.
Tell me about some of your other work with the Illinois Prison Project.
Sure, yeah. We have 3 sort of big buckets of work: direct representation, where we represent directly incarcerated people. That's how we represent people who are medically incapacitated or terminally ill. We also represent people who are suffering from serious mental illness. We represent people serving natural life sentences on cases like armed robberies and drug cases, which, yes, we have here in Illinois. We represent folks who were emerging adults, so under the age of 21 to 24 when they committed their offense. and a variety of other cases where we're directly helping incarcerated people. We also support incarcerated people and their families. We have a bi-weekly Zoom legal clinic. So if you're a person supporting an incarcerated loved one and you have a legal question, feel free to join us. It's a free service. We are here to answer legal questions. And we send resources directly into the Department of Corrections. So we have incarcerated folks on staff right now who wrote their own clemency petitions using our resources, which is really incredible. We also do a lot of community education. So we go and speak to schools and workplaces and churches about the harms of mass incarceration, about the really amazing people who are caught in our criminal legal system now, and about their own personal stories of rehabilitation. And finally, we do some policy and advocacy work. So working with system players to improve our criminal legal system. And the Joe Coleman Act is a really good example of that.
Yeah. Well, in our final few minutes here, because part of your work is kind of being represented by doing something like this, doing an interview, educating the general public. And it's gratifying for me to be able to talk with you for about a half hour so that folks can hear the context of this particular story about the Joe Coleman Medical Release Act, but also the larger work that you do. And it occurs to me in the context of our political environment, very often this issue in particular, anything to do with crime, anything connected to crime, is exploited for political gain, often in 30-second television ads, very short statements that don't offer context, that don't offer the full story. And a lot of people argue this is really dangerous for safety, for all of us, and for the integrity of our justice system.
Yeah, I struggle with those comments because they are so out of line with what the data shows us, with what every other country in the world does, with what we know about the way that people can change and grow, with what we know about juvenile brain development. I will say, just looking at the Medical Release Act as a bit of a microcosm of this issue, we're talking about folks who are going to be dead within 18 months or who are so disabled that they can't brush their own teeth. These are not folks who pose any risk to anyone. And many of them, quite frankly, are serving sentences that were wildly disproportionate to the acts that they committed in the first place. Illinois, to this day, continues to keep people in prison for life for possessing less than 10 grams of crack cocaine in their own apartments. I have two clients serving natural life sentences, both of whom had less than 10 grams of crack cocaine in their own homes. And so I think what's happening is we have a system that has been extreme for decades now. Illinois got rid of parole. We got rid of mechanisms by which people who have been rehabilitated and reformed can even seek to come home. And that has left us with a prison population that is getting older and older and sicker as we refuse to release anyone. So we're now being crushed under the weight of our own sort of errors in judgment. I understand that it's very easy to resort to lock them up as the answer to all of society's ills. But if mass incarceration worked, the United States would be the safest country in the world. And we're not, because it doesn't.
Yeah, very important points. And I really appreciate you joining us today to share so much more information on the Joe Coleman Medical Release Act, but also your other work, because I think in general, folks don't have enough information. I certainly, through this reporting and then through our conversation today myself, learned a lot about these issues. And so hopefully through learning, through education, there will be that opportunity for growth.
Absolutely. Thanks so much for having me.
And thank you for watching Capitol View. For all of us at WSIU, I'm Fred Martino. Have a good week.